Good morning, everybody. Welcome to Truth and Transparency. Happy Thursday morning. Recapping just really quick. This will be the live coverage and streaming of the Sheldon Jeter Jr. Supreme Court for Pennsylvania. Here we go. All right, guys, again, good morning. Rachel Daltondo's murder, 2018. She was shot on Mother's Day around 10:30 p.m., 10:50 p.m. Mother's Day at the bottom of the driveway of her parents' home where she lived at the time on Mother's Day. Shot. She had just gotten dropped off from going to get ice cream with one of the police sergeant's daughters and another boy who happened to be the half brother of Sheldon Jeter Jr. While Rachel and Lauren, the friend, the girlfriend, they had a little bit of a gap in the years. They were texting in the car, which is strange, but they said that, Lauren said that she was trying to get rid of Ty and told Rachel to go for a walk. I don't know, go for a walk. I'll drop him off and I'll come right back. Where Rachel Daltondo was dropped off is where Rachel Daltondo's body was found. Now, normally you would think that persons of interest would be the last people to see Rachel Daltondo alive. To this day, Rachel Daltondo's murder has not gone to trial. But what would happen a year and then 2 years after this incident would be where I came in to help the family of Sheldon Jeter Jr. and advocate for his innocence based off of the information that I had. But it was kind of too late because it was right before the trial that he would actually have for a different homicide, which I want to show you guys right now. And that is what Sheldon's in court for. Sheldon Jeter Jr. was railroaded and framed based off of the discovery. If you actually got your hands on it. I did a 3-part podcast on it. It's called Sunset Secrets. Episodes 1, 2, and 3. What Sheldon Jeter Jr. is back in court for is during the first trial, when I was there, they don't film, they don't show it. They can't live stream those in Pennsylvania. So when I was there, I started overhearing people talk about one of the jurors and that this juror was the neighbor of Rachel Daltondo and that she made it onto Sheldon's jury pool. But not only that, she was Rachel's neighbor, but she was also the estranged wife of one of Sheldon's distant relatives. And there's some animosity there because the estranged husband of the girl who was the neighbor of Rachel, who made it onto the jury, her estranged husband was one of the people that found Rachel's body that caused them issues down the road. Long story short, I happened to be visiting with Rachel's parents, who I adore. They're phenomenal people. And as I was leaving or coming, I couldn't believe my own eyes when I saw the juror, in fact, pulls up in a car, is staying there at the house. That's her parents' house. She had a kid, little baby, and is 100% the chatter that was going on. I started taking pictures, rolling video. I couldn't believe it. how in the world does somebody, I mean, Rachel lived on Buchanan Street. Everybody in that area is 9,000 people. Everybody knows, based on the high publicity that was around Rachel's case, everybody know that they know Buchanan Street. That's Rachel Del Tondo Street, just like Orchard Street. That's Sheldon Jeter Jr. Street. Okay, because it was constantly in the media. So it's like, how in the world does Rachel Del Tondo's neighbor, like I'm talking about next door neighbor, get on Sheldon Jeter Jr.'s jury? Not only that, then the juror was communicating with her father about the trial, and she was praying before they were doing jury deliberations on how she should deliberate and how she's bringing God in as a 13th juror. So I wanted to know, first of all, I wanted to make sure that all of this was accurate before I was to turn over any information. But I was really curious about what type of questions were asked during the voir dire process. How does this happen? And who Sheldon Jeter Jr. had as his representation was Santa Cola and another guy out of Philly. They didn't even open up Sheldon's discovery. They didn't even look at it. They didn't call any witnesses. They didn't, it was so ridiculously, not one, I think there was one motion to suppress. I couldn't believe my own eyes when I watched that trial. These weren't public defenders. These were paid for attorneys. Okay. His family, like I said, you saw Bear there, Michael Moreland. So Aliquippa became like a second home to me as I was traveling back and forth like every other week, being there for extensive periods of time, interviewing people, doing all the things that were never done to be able to provide a binder with stuff that was from the discovery, putting it all together, showing all these police reports, and that they are totally like there's now no dates on them. Stuff that was said that they couldn't have done because buildings weren't even open. There's no chain of custody. It is absurd. We have officers in Aliquippa getting in people's cars, driving them, moving them out of the crime scene, taking photos. Then they get into Sheldon's car that night, drive his car after being in somebody else's car. So I just uncover all of this shit. And it was too late that I had found out about him being arrested and charged with a good family member friend murder. And basically what I was able to uncover is that Sheldon Jeter Jr. was set up, but it was a double cross. There's in the mix of this is police officers and family. It was a horrible situation for anyone to be in if you are a family member that might know something, and then you have to basically pick and choose what side are you gonna open up your mouth and tell the truth, or are you just gonna stand there in silence? So today, Sheldon, he has an appellate attorney, and he is arguing they won a ruling back. So he was convicted in 2021. They said that Sheldon went home and slept with a gun after shooting a man. He went home and brought the gun home and put it underneath his mattress. But meanwhile, with the Rachel Del Tondo case, 2 years prior, the gun has never been found. He was never charged in that. They can't charge anybody in that case because it would bring out a can of worms of what the police department and people that are in power positions in Aliquippa were doing. That case will never be brought probably because of that, because it will out all that shit. Sheldon Jeter Jr. did not kill Rachel Del Tondo. Sheldon Jeter Jr. did not kill Tyreek Pugh. And everything points towards the police involvement and then it being covered up then by PSP by not doing their job. When I say everything points to it, there's physical evidence. There's a science that you just cannot overlook. It happened to be raining on the night that Tyreek Pugh was killed, but right before it was raining, it wasn't raining. The pavement was dry. It starts raining right after he was shot. So underneath the body of Tyreek Pugh outside on a street, it's all dry underneath. And you can start seeing that around him, the pavement starts to get wet, so it starts to get darker. And then when his leg, because he was shot 6 times in the head, when you could see his leg and you move, there's going to be like basically an out like a chalk. But what one would look at if these fucking lawyers would have ever even opened up the discovery, they would have been able to look at the crime scene photos and see that cars were moved out of the crime scene tape. Number one. Number two, there was a police officer's vehicle that was supposed to have arrived after one of the witnesses arrived, right? Well, one of the witnesses, it was wet underneath his car. Like, it should have been dry if, in fact, he was there when Tyreek Pugh would have been there, or just moments after, because it was dry underneath Tyreek Pugh because it wasn't raining yet. What I was able to locate and see is that underneath the police vehicle, it was dry. How's that possible? That would mean that the police vehicle was there before it started raining, just like Tyreek Pugh was there before it started raining. Sheldon Jeter Jr. was being followed around, and Sheldon Jeter Jr. was lured up to that hill that night to bring medicine not once but twice. There's a family member that has not gone to prison and should have gone to prison for a huge ass fentanyl ring that was being trafficked through the mail. That's where Sheldon Jeter Jr. went to bring gout medicine to his family member that night. The 911 caller, the location of the 911 caller was not on Keel Street. I found that out. I was able to find out that the 911 caller was actually in Baden, Pennsylvania. But here the 911 caller is standing over the body, allegedly saying that it looks like the guy got hit by a car. How could you ever look and be standing over a body that had 6 bullets in its head? How could you ever say that the guy got hit by a car? You couldn't. You wouldn't. Well, it makes sense, though, when you look at the 911 caller's location, and it was 6-7 miles away. It's problematic. Then you look at the surveillance cameras, and they said that the 911 caller was driving a van. Yeah. They said that the 911 caller was driving a Dodge based off of the surveillance cameras. This is the car that would have been moved out of the crime scene photos. But thank God there was one report. Thank God there was one report that talked about one of the responding officers wrote up his report, thank God, and put that this car was a Chrysler Town. And then I found the 911 caller's house. He had 4 different vans. They all had temporary or no tags. So yeah, Sheldon's been waiting for this day for a very long time. And this is about the Juror. They won in 2022. The state appealed it, though. And so here we are now, 2025. This is still a direct appeal. That now it's all the way up at the Supreme Court for Pennsylvania. And it has to do with the Juror. This is juror misconduct. This is automatic retrial. If for some reason Sheldon does not win this, Sheldon has every way possible to make ridiculous appeals based on ineffective assistance of counsel. I believe that there's Brady violations. They didn't make one discovery request, his attorneys, not one supplemental request. Meanwhile, knowing that they were missing so much I mean, you read the first report and you know that there is no chain of custody on the surveillance cameras that they said that they went and saw that night at 1:30 in the morning. Meanwhile, the two people that went and supposedly got this surveillance video were inside the crime scene tape from 1:32 to 3:32. I'm sorry, 12:34 until 3:32. How could you go and get footage from a convenience store that closes at midnight during COVID, has all these 27 cameras, doesn't have you on a single one of them? I went and talked to them. That person was scared as shit. Like, how many times have you ever heard of a death notice being given? I'll tell you why Tyreek Pugh was the one that was the bait for this. Tyreek Pugh on his driver's license had the same address as Sheldon Jeter Jr., not because they lived together, but because Tyreek Pugh never changed his address from 2014 when he was coming and going from Sheldon's grandfather's house all the time. I was able to locate in 2019 that Tyreek Pugh got involved in a altercation of some sort, disorderly conduct. So Rachel Altano gets murdered in 2018. Tyreek Pugh gets arrested in 2019. The arresting officers realized that Tyreek Pugh had the same address as Sheldon Jeter Jr. If anybody knows how a death notice works, is if you have your ID on you and you're killed, they cleared that crime scene at 3:32 in the morning. Meanwhile, they found the body at 11 in the middle of the road, and they cleared it all up by 3:32. 6 troopers and police officers went to give a death notice at 127 Orchard Street. Went straight there, lined the fucking street with copper car, like troopers and police officers. What, have you ever heard that in your life? That wasn't a death notice. And then when they were walking up to give this death notice, they said, "Oh, wait, you see that traverse right there? That's the traverse that was on the surveillance footage that we just reviewed, that we just went and picked up at 1:30 in the morning that we didn't really pick up." But it's like, how would they know that that there would be a traverse on the surveillance cameras? Because they were involved in the setup. Then I was able to find out that one of the people that responded to the scene, who was a police officer in Aliquippa, wasn't actually working that night. And his home is 15 minutes away from the crime scene. And he was there within 1 minute of the 911 call in his personal use vehicle that happens to match one of the vehicles that is seen on surveillance camera right before the shooting. I uncovered all of this. I put this all together for the family for free because I believe in helping people that don't have a voice, that are innocent, that are wrongfully convicted, that are wrongfully accused. And then on top of it all, corruption. Sheldon Jeter Jr. was targeted. This was all planned. And once I saw that license had that address and it was a beeline straight there, and then boom, all of a sudden they just start interviewing at 3:30, 4 o'clock in the morning, people in that house. They didn't have a search warrant or anything like that. There was no probable cause. There was nothing. They had to come back, and they came back. I don't know how many hours later it ended up being. I want to say 4 or 5, maybe even more. Let me tell you something. If you have a gun that you shot and killed somebody with, right, and the police leave, wouldn't you take that gun that you have that's underneath your mattress and get rid of it? The cops were just there. They just talked to you. They just talked to your grandfather. Then they leave. And if you just supposedly shot and killed, like Sheldon got in the back of the cop cruiser and was interviewed that night at 4 o'clock in the morning. They did a gunpowder residue test. He passed. Nothing on him. Then the cop says, "Hey, can we take your vehicle?" The same guy that moved the car out of the crime scene gets in Sheldon Jeter Jr.'s SUV, 10-2, pulls it away. Then miraculously, they find gunpowder residue on the steering wheel. You got to be shitting me, right? On the way to the barracks to take this car, SUV, the SUV breaks down, allegedly. Then they have to get it towed. Then we notice that there was no evidence blanket put down in the car like you're supposed to do it, right? But when the pictures show up from the tow truck, like a Sally Port sitting in a car, there's miraculously this evidence blanket that's sitting to make it seem like, oh, this was so kept well. But yet Sheldon Jeter Jr.'s family had cameras all over their fucking property because all the cops were like bothering this young man. And his aunt, who lived right across the street, her cameras was able to catch all of this. And not one officer approaches that vehicle and puts a blanket in there, an evidence blanket, before that cop drove away. How does this not all get suppressed? How are you just driving vehicles? How are you getting in? How does a lawyer not even know that this officer had got into the 911 caller's van just hours before and then gets into Sheldon? How do you not know that? You just have to open up the discovery and read literally the first interview, which was with the 911 caller, to know and to just listen to it. It's a 12-minute recording. And to hear, wait a second, they moved a van out of the crime scene and an Aliquippa cop did it? The same Aliquippa cop that then moved your client's fucking van or SUV? Sheldon Jeter Jr. was railroaded, framed, and double-crossed. And Tyreek Pugh, was double-crossed. Tyreek Pugh was the bait and died that night to be able to frame Sheldon Jeter Jr. and to be able to get all eyes off of the Rachel Del Tondo case, because then they were going to try to dump that on him as well. Let's just say me covering this case caused me a lot of headaches and heartaches. But I'm not the type of person that just runs away because people are human garbage. Rachel Del Tondo deserves justice. Tyreek Pugh deserves justice. And Sheldon Jeter Jr. deserves the truth. And he deserves to be vindicated. And I believe that my work has already begun that process. But this process is taking way too long than it should. And I know some people out there have Pennsylvania licenses and they do wrongful convictions. And this is a case that is worthy of your time. I welcome the opportunity to provide all of everything that I've put together in this case and provide it to the right hands when trial 2 comes along. I know there's people out there that do it. I know they're really good at it. And this is a case. It's the winning case. It's the winning hand. The evidence is all favoring of the innocence of Sheldon Jeter Jr. and the framing of him. What his lawyers did in this first trial is disgusting because they didn't do anything, nothing. If you want to know more about what I did, like I said, Sunset Secrets, if you punch it in my channel, there's episode 1, 2, and 3. I methodically go through everything for the viewers and anybody that would want to take on this case to point out that, this is, in my opinion, after all the cases that I've covered now, this is the easiest case to put together the dots. And it was just so sad that the people that Sheldon put his life in their hands, these lawyers didn't even bother to open up the discovery. You hear about 68 terabits for the Brian Kohlberger case. I can fit all of Sheldon's papers in one big binder. That's it, just one big binder. And then the digital stuff is just on a 1 or 2 terabit, not even, it's just his phone. That's not a criminal investigation. Okay. It's sad. So let me share this link. They get started here at We got 5 minutes. So there's a couple cases that go. Sheldon's is the second case. Again, these are the oral arguments. It's the Supreme Court oral arguments. It happens down in Pittsburgh. And it's the Supreme Court of Pennsylvania. Thank you so much there. Sorry, guys, I'm working on my voice from yesterday, like almost 10 hours straight. Thank you guys for all your kind words. I found a lot. I found the juror with the help of the chatter in the courtroom, and I was lucky enough to get it all on recording device on a public roadway, which is not illegal. I was standing on a public roadway when I recorded the juror getting in and out of her vehicle on the public roadway coming from the house. Nothing that I did was illegal or anything like that. It was just and it's true. There was affidavits put in this case. And so all that, I was interviewed by, what was it, NBC. Nicole Ford did a great job with, she's probably one of my favorites in terms of mainstream media people that are fair. We did a segment with Sheldon's family, had them down at the church, and that was in 2022, right before the oral arguments where they won, and then the state appealed. So now it's back in front of the Supreme Court. But something that nobody can deny is the fact of there's a cop car that's there, and it's dry underneath, and the cop was supposed to be there after, and it should be wet underneath his cop car, and it's dry. That's science. That's God. That's God right there. God, if it wouldn't have started raining at that time when it did, you can never prove that. You can prove this, like, that's your reasonable doubt. You can prove that the cop car was there before it started raining, which is just unbelievable to catch. I caught it. If I would have had that discovery and had that stuff, Sheldon would have never been convicted in the first place. Sheldon and the family agreed to let me look at the discovery, and the lawyer shut that down. It was the client said that he wanted me to do it. The family took me to the lawyer's office and everything. What happened in that case was nothing that I've ever seen in my life. They basically buried their own client, man. It's just unbelievable. Unbelievable. He was arrested. Sheldon was arrested within 24 hours of the homicide of Tyreek Pugh without so much as one report written up. Sheldon's been in jail since May 16th, 2020 for a crime that he didn't commit. It's really sad. Okay, I'm going to go over here to the live stream. Again, thank you all for being here. This case professionally means a lot to me, and this case personally means a lot to me. And like I said, if anybody is deserving of anything, it's someone like Sheldon. We're just waiting on the Supreme Court, guys. Frank Catropa just landed in some hot water back a couple months ago. I want to say 6-7 months ago. He was arrested. Frank Atropa was the fiance of Rachel Del Tondo. He was arrested back 6-7 months ago for strangling his baby mama and attempting to destroy evidence on her phone. That has since gone, like, nobody's reporting on that. So I have no idea what's going on. I've been following the docket, but I do know that Frank Atropa's, the same woman, is alleged to be Frank Atropa's alibi the night of Rachel's murder. But I also know something else. The behavior of Frank that night and how he was blowing up people via the telephone that night, and acting really, really strangely before the homicide of Rachel Del Tondo. I'll hit the bell. Thank you so much, Jen. I just got to catch up. $20. Thank you for the work that you do. Appreciate that.
The Honorable, the Chief Justice and Justices of
Here
the
we go.
Supreme Court of Pennsylvania. Oh yay, oh yay, oh yay. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to our third and final day of our spring oral argument session here in Pittsburgh, and the third day of absolutely different weather that we have every day in Pittsburgh. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated our court's historic 300th anniversary in Philadelphia, and we on this court are very proud of our court's rich history. It's truly an honor for us to sit in three magnificent courtrooms in Philadelphia, Harrisburg, and Pittsburgh. I'd like to mention a little bit about our Supreme Court history before we start the arguments. As you likely noticed when you were entering the courtroom, our court has a tradition of hanging oil portraits of former Chief Justices in our courtroom space. Yesterday, I spoke about Chief Justice James Drew, Chief Justice James Sterrett, and Chief Justice Robert Fraser. And I wanted to just mention the remaining Chief Justices on the wall, just as a point of interest. In 1961, by way of background, Governor David L. Lawrence appointed Pennsylvania's Attorney General Ann X. Alpern to become this court's first appointed female justice. However, in order to win a full term, she had to run for election, and she had to defeat Henry X. O'Brien, who she didn't defeat. Thus, he's the fourth justice pictured there. Alpern lost a very contentious election. During Justice Henry X. O'Brien's term as Chief Justice, he established our Lawyers' Client Security Fund to reimburse clients who were defrauded by their lawyers. O'Brien served as Chief Justice from 1980 to 1983. To his left on the wall is Chief Justice Samuel Roberts. After graduating from the University of Pennsylvania, Roberts entered a lengthy private practice in his hometown of Erie. He served in World War II in the United States Navy and was later elected to the Erie County bench and later to our court in 1962. He became Chief Justice of Pennsylvania in 1983 and served until 1984, after which apparently he was a glutton for punishment. He became a senior judge on the Superior Court and a special master for the U.S. Supreme Court. To his left is a justice many of us knew, Chief Justice John Flaherty. After graduating from law school, he opened a solo practice in Mount Lebanon here in the Pittsburgh area, while at the same time teaching at Carnegie Mellon University. He was elected to the Allegheny County Common Pleas bench and gained notoriety for his controversial decisions, including closing an all-black middle school in Pittsburgh for illegal segregation and ordering the removal of fluoride from 26 communities' drinking water, an order that was later overturned on appeal. He was elected to this court in 1979, and he served as Chief Justice from 1996 until his retirement in 2001. Next to Flaherty is Chief Justice Steve Zappala, an outstanding athlete. Zappala played basketball for Notre Dame before moving back to Pittsburgh to play for Duquesne University. After serving in the Army, Zappala graduated from Georgetown Law School and returned to Pittsburgh to practice with his father and brother. He was elected to the Allegheny County bench in 1979, and 2 years later to the Pennsylvania Supreme Court. He served as Chief Justice from January 1st of 2002 to December 31st of 2002. While on the court, he initiated, developed, and fully integrated the largest computer automation system of any type in our country. Next to Zappala is Chief Justice Ralph Cappy, which is fitting because I believe they were always together. Cappy graduated from the University of Pittsburgh School of Law and entered private practice before beginning his public service in the Allegheny County Public Defender's Office. He became the director of that office before being appointed to the Common Pleas bench by Governor Shapp. He won a seat on our Supreme Court in 1989 and became Pennsylvania's Chief Justice in 2003, serving until his retirement in 2008. Chief Justice Cappy died unexpectedly in 2009, shortly before the opening of Pennsylvania's Judicial Center in Harrisburg. Because of Chief Justice Cappy's efforts in planning and developing and securing funding for that building, his portrait hangs in the Judicial Council room on the first floor of that building. Finally, our late colleague and my predecessor, Chief Justice Max Baer, he began his public service with the with the Pennsylvania Attorney General's office before moving to private practice and later to the Allegheny County Court of Common Pleas. During that time, he fought tirelessly to reform the juvenile justice system. After receiving national recognition for those efforts, he was elected to our Supreme Court in 2003 and spearheaded several initiatives to help speed up the appellate process for domestic cases involving children. He became Chief Justice in 2021 and served until his unexpected death in October of 2022. All of these Chief Justices from the Western Pennsylvania area are a part of our rich heritage of our Pennsylvania Supreme Court. Before we hear the first case, I would like to remind counsel of a few things. First of all, appellate counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent, and please introduce your co-counsel to the court, if any. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. Please remember that we do not allow rebuttal. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices while we are asking you questions, although we may be interrupting you. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we want to explore further. While there's no set time for argument in our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
City of Pittsburgh versus National Hockey League Players Association et al. Representing the city, Mr. Yazan Ashwari, representing the NHLPA, Mr. Ryan McManus.
In this appeal by allowance, we must determine whether the city of Pittsburgh violated the uniformity clause by requiring professional athletes who reside in the city to pay a 1% earned income tax while requiring professional athletes who are not residents of the city to pay a 3% tax on any income derived from their usage of the city's publicly funded sporting facilities. The issue is a little more complicated and nuanced than that, but I trust you will enlighten us. Please proceed.
Thank you, and may it please the court. My name is Yaz Ashrawi, and with my colleague and co-counsel Jordan Blask, we're here on behalf of the appellant, the city of Pittsburgh. Your honors, the purpose of the Pennsylvania Uniformity Clause is to ensure rough equality and rough uniformity in the assignment of the tax burden on subjects within a particular class. And the facility fee at issue in this case does just that. And it certainly does not clearly, palpably, or plainly violate the Uniformity Clause. We're asking that you reverse the Commonwealth Court decision and uphold the tax, particularly in light of the presumption of validity that is afforded to this facility fee, the tremendous discretion that is afforded to local governments in matters of taxation, and the heavy burden that a challenger must overcome in order to strike a tax down. And as this court has said, any doubt about the constitutionality of a tax statute must be resolved in favor of upholding it. But there should be no doubt here. The facility fee at issue in this case does the exact opposite of create disparate or unequal treatment. It equalizes the earned income tax burden on a class of individuals.
Just to clarify, you're referring to it as a fee, but it is a tax.
Yes, Your Honor. The city has conceded it is a tax, and for that reason is treated as a tax. And there's no issue on that point, of course. It brings parity and equalization where parity and equalization did not exist prior. Now, regardless of an athlete or entertainer's residency, whether they live in Pittsburgh or Philadelphia or Columbus or Boston, they pay a 3% earned income tax on remuneration generated by performing at one of the city's publicly funded facilities.
How does that relate to the taxes the non-city residents pay to their home municipalities?
Your Honor, because it is a tax, it can be used or considered for credit purposes just like any other tax can. And when you look at the language of the Uniformity Clause looks at tax uniformity within the territorial jurisdiction of the taxing entity, which would be the city of Pittsburgh. So while there could be a plethora of other taxes that non-residents pay, whether those are non-residents that still reside in Pennsylvania or non-residents that reside elsewhere in the United States, there's going to be differences among those other taxes, no doubt. But the key here is, under the plain language of the Uniformity Clause, the burden on earned income tax at these publicly funded facilities is the same. It's 3%.
But counsel, on the balancing, how can you aggregate a burden here that the non-residents would in no instance have been permitted to be assessed? I'm talking about the city of Pittsburgh school district tax. That could never be laid on the non-resident performers. So how can that come into the mix here?
Certainly, the reason it comes into the mix, Your Honor, is because it is a tax on the same subject. And when you look at the uniformity clause does not look at who the taxing entity is, and neither does this court. In Sharon v. Minnick, for example, the residents paid 10 mills on their income tax, while non-residents who worked in the city of Sharon also paid 10 mills on their income tax. Half of the millage, half of the revenue for the residents was allocated to the school district, a tax that non-residents are not subject to. And they raised the same challenge that has been raised here. And this court in Minnick looked at the overall tax burden on the same subject, earned income tax, determined that the overall tax burden was the exact same, and found no issue with respect to the uniformity clause.
But here in the city of Pittsburgh, they're two separate taxes, right? Not talking about the sports add-on, but just generally, the school district 2% tax is separate and apart from the 1% income tax. Is that correct?
It is the school income tax, the authority to levy that is separate. The tax itself is the same. It is an earned income tax. For example,
Right. They're
yes,
both earned income taxes. but
Correct.
They are separate.
there are separate entities that impose them. But that is exactly what happened in Minnick, and it also exactly what happened in the instructive Frey case out of the Maryland Supreme Court. In that instance, there was residents of Maryland paid a state income tax that non-residents that made money in Maryland also paid. Residents then paid a county income tax dependent on the county in which they reside. That the totally separate, imposed by the local county. The non-residents could never be subject to that tax. Instead, Maryland enacted a special non-resident tax, on its face applicable only to non-residents. And that special non-resident tax was equal to the local county tax that the residents paid. So there you have two different entities imposing same income tax under two different sets of authority, and then a special non-resident tax to equalize that burden. And Frey was.
I'm sorry to interrupt, counsel. Could I just go back to Minnick for a second?
Yes, Your Honor.
When I read that, it's a short case, but from what I gleaned there, it seemed like the tax, correct me if I'm wrong, in Sharon there, it was a 10 mil income tax on residents and non-residents alike. So isn't that right? So I mean, you have a difference, a distinction with a difference here, as opposed to what between that and what's going on here, don't you?
Not precisely, Your Honor. Minnick was very short, but if you read the ordinance at issue in Minnick, it did two things. It imposed a 10 mil tax on residents of the city of Sharon, period, irrespective of where they worked. Separately, it imposed a tax on non-residents that worked in the city of Sharon. So facially, it distinguished on residency, right? So you could be a resident of Sharon and work elsewhere. That 10 mil tax still applied to you. But if you're a non-resident working in the city, that now applies to you. So slight difference. Regardless, if you look at the present case and you look at Minnick, you have two different taxing authorities. You're talking about an income tax on earned income, the same subject that is burdened by that tax. You're talking about non-residents paying a greater amount on the back end revenue-wise to the city in which they are not residents, exactly what's happening here. And you have a tax, as I just pointed out, that was not facially neutral, just like this one is not here. At the end of the day, the court, looking at the local enabling tax, which is still applicable today, it's been amended, but the pertinent language still remains, looks at the total tax burden aggregated for a single tax. And that is the earned income tax. And that's why the Commonwealth Court's reliance on Danny Luck is not correct. Danny Luck.
Before you get to Danny Luck, can I ask, go in a slightly different direction on the uniformity? What earned income tax does a non-resident pay in the city of Pittsburgh that doesn't work that is not an entertainer or athlete?
It depends, Your Honor, on a number of things. So if you are a non-resident of Pittsburgh that works there but lives in the state of Pennsylvania, the city withholds the greater of the income tax that the city imposes or the income tax that is imposed by your resident jurisdiction. The city collects it, and then it allocates it based on the difference there. So if your local jurisdiction, your resident jurisdiction charges less, it provides that allocation to your resident jurisdiction. It maintains the balance. If it's greater than, it pays all of it to your resident jurisdiction, and you still owe your resident jurisdiction money. If you are a non-Pennsylvania resident, you owe a 1% income tax to the city of Pittsburgh. And I want to be very clear also.
What if you're, I mean, so here's my concern about this special taxation for entertainers and stadiums. And the hook seems to be that they're publicly financed facilities. At least that's the hook that the General Assembly seemed to come up with. Courthouses are publicly financed facilities. Hospitals, to many degrees, are often publicly financed. Airports are publicly, I mean, we could go down the publicly financed road. Is it constitutional then if the General Assembly wanted to sort of piggyback off of this framework and create a very similar law for attorneys that are not living in the city of Pittsburgh but come in and appear in courthouses or buildings? Would that be a constitutional framework?
Under the uniformity clause, Your Honor, if the overall tax burden on that class of individuals, lawyers that appear here, is equal, it would be, so long as there's enabling state legislation. Now,
Okay, so we can treat professions from a taxation perspective differently.
no, Your Honor. I'm sorry. We're looking at the uniformity within a class of subjects. So in the facility fee, that class of subjects is the earned income made from performances at those facilities. And there's no...
And the earned income we're talking about is the earned income made by lawyers who appear in courthouses.
Certainly. In that instance, there may be a uniformity.
This is Tina with What the Fuck Transition Services. What the fuck are y'all talking about? Let's be real.
Education I'm getting to.
Oh.
I'm trying to understand. We're not allowed to classify or change classification based on how much money. We know that's the law. You
Correct.
can't do it by money. I'm wondering whether you can constitutionally do it by profession.
You can constitutionally do it based on legitimate business and policy related reasons. And there's only been...
What's your source for that? I mean, what's
the only case related to...
The hook here is it's a publicly financed facility.
It's the athletes and entertainers that perform there. And the hook there is from a business and policy perspective. And there's really only one case in the nation on this, and it's out of Ohio. The court has said in the Hillenmeyer case, when you look at the justifications and rationale for treating athletes and entertainers differently, they demand a greater amount of resources for security and safety and traffic control and police protection and stress on the local infrastructure.
Sounds like judges.
Exactly, Your Honor. There's about as many people in here as there were at the 13-inning game last night here in Pittsburgh, right? So in any event, those real world considerations and those real business considerations can be used for classification. Classification in and of itself is not prohibited. If there's classification, there needs to be a reasonable, rational basis for that classification.
And that's why not everybody that works at our sports stadiums falls into this. This is just athletes, entertainers. This isn't the guy selling the beer or the popcorn.
That's correct, Your Honor. It's athletes and entertainers that perform at those stadiums, and that's defined in the local code, that have the 3% tax burden on their earned income.
And only the non-residents.
Only the non-resident athletes and
So
entertainers.
The city's claiming then that tax is necessary in effect to cancel out a different tax, the school district tax that only residents of the city of Pittsburgh pay, right?
I don't think it's so much as canceling out, but it is equalizing the tax burden, because if you are a resident athlete or entertainer, right, and in our class here are athletes and entertainers. If you are a resident athlete or entertainer, you live in the city of Pittsburgh, you perform at one of those facilities, you are taxed 3% on the income generated there. Now, with the facility fee, if you're a non-resident, if you live in one of the suburbs, if you live in Philadelphia, if you live out of state, you also get taxed 3%. Now, what happens after that money is collected is different, but that's never been a determinative of a uniformity clause challenge.
Doesn't it look a lot like what the court put the kibosh on in that Johnstown tried to make the same move in the Daniluk case?
It's very different, Your Honor. And let me go through those distinctions and why Daniluk does not apply here. There was only one taxing entity in Daniluk. It was the city of Johnstown. So if the city said we've got a 1% and let me back up, there were two different types of taxes. So the subject of the tax was completely different, right? So if the city of Pittsburgh said, we're going to tax residents 3% on earned income, and we're going to equalize that burden on the non-resident athletes and entertainers by taxing them 3% on the value of any real estate and assets they hold in the state of Pennsylvania, that would be a different case, because the subject of the tax, which is what the uniformity clause looks at, is different. And that was the case in Daniluk. In Daniluk, there was one taxing authority, two different types of taxes, a head tax and an occupation tax. There was, and the main holding in Daniluk was that the head tax on non-residents was per se invalid. Why? Because the purpose of a head tax is to provide revenue and resources for services specifically for residents, right? So the subject of a head tax are residents. Non-residents cannot be subject to a head tax. And
Voodoo economics. Voodoo economics. Bueller.
reaffirm the fact that that the head tax was per se invalid on non-residents, with dicta related to the uniformity clause if there
With
were
dick is what I
an
heard.
occupation tax set on both, because occupation taxes are different than earned income taxes. So the two cases that are most factually similar to our case, Minnick v. the City of Sharon, and even more so, Frey out of Maryland. There you have two taxing entities equalizing an income tax burden on non-residents that facially calls out non-residents. In both cases, this court and the Maryland Supreme Court upheld those special non-resident taxes because the overall tax burden was the same.
I'm still trying to understand this overall tax burden being the same for non-residents. I'm not talking about non-resident. I'm sort of focusing when I hear non-residents of Pittsburgh, not someone who lives in California who's coming in for an event.
Sure.
So let's assume the Pittsburgh Steelers draft a quarterback. That quarterback's going to have an option. Maybe move into the city of Pittsburgh, maybe move into Washington County. If that quarterback moves to Washington County, is that quarterback going to pay 3% to the city?
Yes.
Oh,
Even though they may
shit.
be paying 3% to Washington County and their local school district?
Here's the distinction, Your Honor. And
Not just the answer first, then you can give me a distinction.
they may not be paying that 3% to Washington County or the local school district. And if they are, there's a credit option. And I want to be very clear. This income that is generated, let's take that example. The income that is
3%
generated
for an
at
athlete's
those
lot.
facilities is taxed one time, right? So if that quarterback goes and plays the Cleveland Browns or the Cincinnati Bengals or the Baltimore Ravens, those cities will capture the income generated there and charge income on that earned income. So the resident city or county or school district they live in, unless their statutes say something different, can't capture income generated outside of there. And if they can, that's where the credit comes in. And I know there's been discussion on, this doesn't allow a credit. The city has now conceded this is an earned income tax. So it's eligible for credit purposes, just like any other earned income tax.
Tell me how the credit works.
Certainly. So the general purpose of a credit is so you're not taxed twice on income earned at a particular
Where
location.
do they get the credit?
They would get it depending on how the local ordinances are. Generally, they will receive it against income paid to their local residents. So if
Are you giving them the credit? Is the city giving them the credit?
Yes.
Okay, the city is giving them the credit,
Yes,
just as you do with residents.
correct.
Credit for their school district earned income tax.
Correct. Now that the city has conceded this is a tax, it will be an earned income tax. It would be treated as such. And again, Your Honor, to go back to both Justice Bronson and Justice Donahue's questions, it's going to depend on where that person resides. Even in the state of Pennsylvania, Philadelphia has a completely different local income tax structure. Other places don't have school income taxes. Some are higher than others. Some don't allow a credit, some do. And that's why the uniformity clause looks at the territorial limits of the taxing authority. So that is, the key is the city of Pittsburgh. We cannot control everything that happens outside the city of Pittsburgh. And that's been discussed by this court in the life insurance of Pennsylvania case, where non-resident life insurance companies, foreign life insurance companies, complained that there were other taxes that they were subject to in addition to the 2% tax in Pennsylvania that domestic life insurance companies were. And the court said, there's never going to be perfect uniformity. In the state of Pennsylvania, everyone pays 2%. That is an equalization. If you have to pay taxes other places for other things, that is part of our taxing system.
But again, I go back to my point. I'm not trying to belabor it,
Sure.
but in the city of Pittsburgh, the only non-residents that have to pay the 3% are non-resident entertainers for the income they earn at a publicly financed facility.
That's correct. There is a separate classification of non-residents and non-resident athletes and
And
entertainers.
the General Assembly, in your view, has the power and the authority to continue to do that kind of classification based on job and location where they do their job.
Based on the real life business interest, yes. Based on the business,
Valid classification, your profession, and where you do your profession.
depending on the profession and depending on the real business implications behind that profession. So again, the court in Hillenmeyer out of Ohio, the only one that's opined on whether athletes and entertainers can be a classification of their own, has said there are real world implications that allow you to classify athletes and entertainers differently than others.
Mr. Eschwag, you are admitted here pro hoc vice from Columbus, Ohio,
Yes, Your Honor.
correct? Could we tax you a little bit extra?
I'm sorry.
As a pro hoc vice attorney from out of state?
If there is a legislative enabling act that allows you to tax income here by me appearing pro hoc vice, absolutely. But for the record, I do pay taxes to the city of Pittsburgh because we have an office here and we generate income here. And therefore, the apportionment of my income,
Because you're a partner at the firm.
correct, apportionment of my income that is citist to the city of Pittsburgh, we pay local income taxes on that. We pay state taxes and other taxes based on,
Pay school tax?
I do not believe so, Your Honor. Yeah. I wish I were an athlete or entertainer. I would
thought you were going to argue that you were neither athletic nor entertaining.
Yeah. That's probably also true, Your Honor. So.
Isn't that because having a law firm here in the city, you have a larger intensity on the municipal services that the city offers?
Certainly, but Your Honor, the earned income tax, and again, I go back to the language of the uniformity clause, and it talks about equal burden on the subject of the tax. The subject of the tax here is the earned income. So the benefit of earning that income is really what's being taxed. This is not necessarily a benefits or a privilege type taxation. We earn income and we pay taxes on it.
Is the credit difference on earned income tax as opposed to the taxes paid by the school district? And the reason I asked the question is because I know the enabling statute, the legislation for the school district doesn't allow the school district to apply an earned income tax credit, earned income tax. So isn't what we're talking about here really an attempt by the city of Pittsburgh to kind of evade that prohibition in the school tax? Because my thought process is when you pay taxes, there's a burden, but there's also a benefit. If I'm an out-of-town athlete or entertainer, I don't get any benefit for that 3%, whereas somebody in the city of Pittsburgh who's equalized gets the benefit of the school district.
Your Honor, this goes to the benefits theory. So first, I will say that because the subject of the tax is earned income, this benefits theory or privilege theory doesn't apply. In fact, and that's briefed in our case. So in the Airway Arms Inc. case, taxpayers may not successfully object on the grounds of the benefits theory to taxation for a general public use, which includes taxes for schools.
Let me back it up to my original point, which was the school district isn't allowed to impose an earned income tax. It's based upon your residency status, correct?
The school district is permitted to impose an earned income tax on residents of the school district, correct?
When we talk about 3% and 3%, isn't this really just an attempt to kind of evade that prohibition?
It is not, Your Honor. It's again, the uniformity clause has never, and this is the key point here. It is not determinative of who levies the tax. You look at the subject of the tax. This is a single tax. It taxes income. It is a public benefit, whether it goes to the schools or if it goes to the city. And whether or not you get any direct benefit from the schools is also not determinative of whether the equalization of the overall tax burden meets the uniformity clause requirement. There are a number of individuals and families that pay the school income tax that don't receive a direct benefit from the schools, but there's a general benefit, as this court has stated and has briefed from a well-functioning, educated society that is also a general indirect benefit that is enjoyed by non-resident athletes and entertainers. At the end of the day, Your Honors, this is a rational basis, highly deferential review of the facility fee under the plain language of the uniformity clause, which requires equal or uniform tax burden on the subject that's being taxed within a particular class. Here we have a class of athletes and entertainers. The subject of the tax is their earned income at these facilities. Not only is the tax burden not disparate, it's identical. Again, regardless of where you live, there will be 3% withheld from your paycheck for money made in the city if you're an athlete or entertainer. The state enabling statute permits this tax. The city didn't do this unilaterally. That state enabling statute still stands, has not been challenged. There's a presumption of constitutionality. There's a heavy burden to strike down this statute. And if there's any doubt whatsoever, it should be upheld.
All right.
Thank you, Your Honors.
Well argued. Let's hear from Mr. McManus. Also pro hoc vice from Boston, I believe.
Correct, Your Honor. Madam Chief.
You get rich today.
We got Columbus versus Boston today. Columbus in the
Madam
house.
Chief Justice, and may it please the court, Ryan McManus on behalf of the Players Associations and the individual plaintiffs. And with me at council table is my colleague, Stephen Kidder. Your Honors, this is a special tax applicable to non-residents only of only particular professions. It is not uniform. And the city's entire argument to the contrary rests on a false equivalency. There's no disputing that a 3% tax on non-residents isn't equivalent or even roughly equivalent to a 1% tax on residents. The city tries to manufacture uniformity here by pointing to the 2% tax to the school district that residents pay, that separate burden that residents pay for school district taxes. Now, of course, non-residents also pay school district taxes wherever they live. City ignores that, doesn't factor into its calculus at
Or
all.
they may or may not, I mean, depending on the tax structure of their resident city or borough, right?
Correct. They pay to fund schools where they live, depending on the structure. It may be a separate school district tax, it may be county taxes. But for example, non-residents of
Well, they pay it
Pittsburgh.
in Pennsylvania.
Exactly. They pay it in Pennsylvania. If you reside in the suburbs, you're paying a school district tax there.
And
This-
getting a credit.
Sure.
You're not getting a credit under the facility fee. That's really important, and I want to clarify that. You're not getting a credit for two reasons. One is, despite the city's admission in litigation that this is a tax, the city's facility fee regulations still instruct that you are not to list the amount paid in facility fee on your W-2 in the local tax box because, quote, this is a fee, not a tax.
That's got to change since they're acknowledging it's a tax, right?
Your Honor, they acknowledged at the Commonwealth Court that that regulation would change. It hasn't. It still reads exactly the same. But that's not the only issue with the credits. The other issue with the credits is that the city is arguing not that non-residents are entitled to a credit against the facility fee that they pay to Pittsburgh for taxes that they pay where they live. They're arguing the opposite. I think I heard different today, but I'll point you to the city's brief. On page 26, they say non-residents living in Pennsylvania are owed a credit for the facility fee against earned income taxes they owe their home community. They're arguing that it's the jurisdiction of residents that should be giving a credit. They're not giving the credit. Now, that's backwards as a matter of state law. The statute provides that you are entitled to a credit in the place where you work for taxes paid in the place where you live.
I mean, I'm confused then because I thought what your opposing counsel was arguing was that the city of Pittsburgh processes the credit, not that they give the credit.
I may have heard it differently, but it's not a question of processing or the mechanics of it. The question is really, where are you paying the tax and where are you entitled to take a credit? Pittsburgh is not giving credit against facility fee taxes that are paid by non-residents. What they're arguing in their brief is go claim a credit where you live.
Right.
There's no statutory basis for non-residents to claim a credit where they live against facility fee taxes paid.
Government may say, well, the regulation says it's a fee. I'm not going to give you a credit for a fee.
Correct.
And you know, they may have a problem with it.
And it's not listed on your, it shouldn't be listed on your W-2.
So as you understand it, at the end of the tax year, there's no form that non-resident entertainers can file with the city that says, this is what you have withheld on your 3% EIT. Here's what I pay locally for school taxes. Give me a credit and give me a refund. There's nothing like that.
Correct. There is nothing like that. So again, the disuniform credits is a significant problem here. It is not the only problem, but I want to be clear. Pittsburgh is not giving credit to non-residents for the school district taxes or earned income taxes those non-residents pay where they live.
Which goes to my.
I understood that, but I guess what I'm having trouble with is that there seems to be some lag in characterizing this through W-2s and what other forms they're generating out of the city of Pittsburgh now that the city has admitted or acknowledged that it's a tax, not a fee. I'm concerned somewhat that is not actually, that there's not necessary follow-up to that admission.
And it requires, Your Honor, not just a change of the regulations and a change of the guidance, but Pittsburgh needs to change its position as to where this credit can be taken. Pittsburgh needs to be giving the credit, not demanding that the jurisdictions where athletes reside give the credit.
Well, I don't understand that because it is up to the jurisdiction where they reside ultimately, isn't it?
Well, by law, by Pennsylvania statute, you as a taxpayer are entitled to take a credit for taxes paid where you live against taxes paid to your place of work. So that's what the statute provides. They're saying that it should be the reverse here. They're
Right,
saying,
right.
and again, that position is not consistent with statute. I want to point out also another issue, in addition to the credits that the city's,
Pardon me, counsel, was this issue argued before the Commonwealth Court?
It-
What was the city's position when this case was argued before the Commonwealth Court? Were they still claiming that it was a fee, not a tax
no, they had conceded that it was a tax.
in the Commonwealth Court?
They conceded it in the briefing before the Court of Common Pleas. That was where they first conceded that it was a
Okay,
tax.
so this has been their revised position, so to speak, for a long time, and it's essentially always been their litigation position.
Their litigation position has always been that
Tax.
the regulation needs to be changed, as I understand it. They acknowledged that before the Commonwealth Court. But their position has also always been Pittsburgh doesn't need to give the credit. It should be given elsewhere. It should be given where they reside. And they never cited anything in support other than the fact
Doesn't
that
that make sense? I mean, because how is Pittsburgh going to give the credit to, with 20 other jurisdictions at issue here? Wouldn't it always fall to the home jurisdiction, home residence jurisdiction to give that credit?
it does not, Your Honor, by law. And for all other wage earners who earn income in Pittsburgh, who pay local taxes where they live, they are claiming a credit against Pittsburgh's tax. And that Pittsburgh is not ultimately retaining that because they have to give the credit. So that is how it works
If
elsewhere.
the city imposed a 3% tax, facility tax on everyone, and the Pittsburgh School District had given credit for that 3% for residents, would that violate the uniformity clause, or would that be uniform?
If it gave uniform credits to everyone, then I think that what you're describing would be very close to what the court was addressing in Minich. If you have a uniform tax at a uniform rate applicable to everyone, residents, non-residents, athletes, and other wage earners, right? There's two critical distinctions here that are being made. If you had a uniform tax like that and everyone was uniformly given credits, then I think this looks very much like the Minich case, and I would acknowledge that. But that's very different from what the city has done here. This is not a uniform tax. And I want to make clear that
When you say has been done here, they aren't collecting this tax now. I mean,
they are collecting this tax.
okay, and so we know definitively that no credit is being given for income taxes paid in the athlete's home state or home municipality.
We don't know that.
I don't know that.
Well,
And
I thought that's what you just said.
what I'm saying is by law, there's no basis for someone to claim a credit where they live. The statute wouldn't allow that.
No, I mean, that's why I asked the question. I mean, if this tax is being assessed now, there's evidence as to how this works. Why don't we know that? Why don't you know that?
Well, all we know is what the law would permit a taxpayer to claim. And the law wouldn't permit them to claim this. So
Why doesn't your client know the answer to that question? I mean,
our clients have not attempted to claim credits where they reside because they don't believe they have a statutory basis to do that. And because they're not listing this on the W-2 because they're following the city's regulations. So they are not claiming credits where they reside. There may be some athletes that we don't represent that are doing that, but our clients are not claiming credits where they reside because they don't think they have a legal basis to do it.
and that was on your advice.
Not my advice personally,
Yeah,
but
well,
they're working with their personal tax advisors as well.
Legitimate question whether he advised them on what the law was.
I also want to point out, in addition to ignoring the taxes that non-residents pay where they reside, the city is also ignoring that school district taxes that residents of Pittsburgh pay by law cannot be imposed on non-residents, and therefore can't justify this separate, even if equivalent, burden that they're trying to put on non-residents.
That was sort of what I was trying to get at earlier. It seemed like an apples and oranges problem. Am I right about that?
You're exactly right.
It was under this enabling statute. Could there be any facility fee that you could envision that would be constitutional?
It would have to be a true fee. I think it's important to keep in mind, the legislature did not authorize a tax. And that's a problem the city's also never grappled with. The legislature authorized a fee. That's significant as a legislator. Whether you're going to enact a tax or not is a significant political decision. They authorized a fee. The city has now conceded that what it's imposed is a tax. And it's a tax in excess of 1%, by the way. State law limits taxes on wages to 1%. They've never explained how they can tax this class at 3%.
Well, I think that the General Assembly sort of knew that what they were doing here was dicey. They called it a fee, even though they put it in the Local Tax Enabling Act. And they specifically referenced on earned income and percentages, which look like a tax and not really a fee. And if it's a fee, then they run into the other problem, which is you're going to have a challenge to the fee. Is it reasonable? Is it, and the argument would be it'd be a tax. It's everybody knew this day would come is kind of what I'm saying.
I think that's right. I think hypothetically, however, under this enabling act, Pittsburgh could enact some type of fee that could withstand uniform. Correct. Something related to the costs of, regulating professional athletes to the extent that they do. And I think just getting back to the apples to apples or apples to oranges comparison, that's really the correct way to analyze uniformity. It has to be an apples to apples comparison. The question is, with respect to a particular tax burden, are taxpayers similarly?
I thought yesterday that Hippler, Ashley Jennings, they're comparing apples to oranges, and Ann Taylor's just like, what the fuck are y'all talking about, man? We're getting bombarded here 2-1.
Property owner in Pittsburgh
We're here for motion
can't be heard
limited.
to object that
We're
their
not here to
neighbor who
argue our
doesn't own
fucking
property
case. There's a trial for
pays
that.
less tax. They're not similarly situated. So that property tax burden isn't going to be considered in a uniformity analysis. For the purpose of school district taxes, residents and non-residents are not similarly situated. By law, non-residents can't be charged with school district taxes. And as to the benefits, I understand, council's argument about not pointing to the various degree to which people benefit from city services. The benefits here are qualitatively different. It's not just a matter of degree. Residents can send their children to public schools, non-residents cannot. So, and that's been codified by law by prohibiting Pittsburgh and other municipalities from taxing non-residents with school district taxes. So you can't look at school district taxes as sort of a justification to impose this 3% tax on non-residents. That's apples and oranges. You've got two apples on the scale, and then Pittsburgh's adding an orange. That's not appropriate.
Isn't that minutes?
No, it's not Minich, because Minich, you had a uniform tax at a uniform rate. I don't agree with the contention by council that Minich had two different taxes. It was a 10 mil tax applicable to residents on all of their income and applicable to non-residents on the income that they earned in the city of Sharon. So you had a uniform tax at a uniform rate, and you had credits that were uniformly available to everyone. The issue in Minich was that residents of the city of Sharon were paying a 5 mil school district tax, and they were claiming a credit for that tax. The plaintiffs in that case were not paying any school district taxes where they resided, and therefore they weren't entitled to claim a credit. There was no distinction being made by law. The distinction was in the personal circumstances of the individual taxpayers. That's very different here. We're not arguing that the court should overrule or narrow Minich. It's a straightforward application of the uniformity clause. Pittsburgh has simply chosen to enact a very, very different tax scheme. And we think that the controlling case here, as both lower courts determined, is the Daniluk decision. In Daniluk, just like Pittsburgh here, City of Johnstown enacted a tax that applied to non-residents only, $10 occupation tax. And like the city here, Johnstown defended that tax by pointing to a tax on residents. It said, well, you have a $10 per capita tax on residents. But like the school district taxes here, the per capita tax in Daniluk could not, by law, be imposed on non-residents. And as a result, this court said that tax burden on residents can't justify an equivalent burden on non-residents. You're not permitted by law to tax residents with non-residents with a per capita tax. That's what this court held in Daniluk, and as both lower courts determined, that is controlling here. That was not dicta in the Daniluk decision, by the way. It's
I'm
a
a dick.
short decision.
I'm
It's 2 pages.
addicted to you.
No fewer than 3 times does
I'm
this
a
court
dick.
say in that decision
I'm
that
addicted
the tax is
to you.
violative of the uniformity requirement. I think the confusion on this point arises from the fact that the court was trying to understand what this tax was. You've got a tax on non-residents only, and Johnstown was saying it's the same as the tax on residents. And the court said it's not the same as the tax on residents because that's a per capita tax, and you can't impose a per capita tax on residents. So this is something different. It's not the same as that, and because it's a different tax applicable to only non-residents, it's not uniform.
Could they redo the ordinance and say, try to bring it more in line with Minnick and just say, every athlete, regardless of where they live, pays 3%. And if you pay a local school district earned income wherever you live, you can get a credit against that.
That would still be different from Minnick in that it would be distinguishing athletes from everybody else.
Well, I asked my questions about that, but let's assume that's okay.
Assume it applied to everyone?
Yeah.
Yeah. So if it applied 3% tax uniformly to residents and non-residents
Gave a credit
of any profession.
You could submit a form at the end of the tax year that says, this is what you withheld from me for this 3%. This is what I paid in local school district, earned income tax. I want a credit. Everybody did it.
If they did that, it would look very much like Minnick, and I think it would be sustainable under the uniformity clause. This is very different in multiple ways. As we talked about, the credits is one problem, but also this does not apply uniformly to everyone. This singles out particular professions and charges them at a higher rate. This court has always treated wage income, which is what this tax is imposed on, as a single class. And it has always stricken down distinctions between and among wage earners. That's why it struck down a graduated income tax in the Kelly case. That's why it struck down the deductions and exemptions in Amadon. And I'll point the court to one more case. It's the Butcher versus City of Philadelphia case. It's cited in one of the concurring opinions in Amadon. It's from 1938, and it dealt with an early version of Philadelphia's income tax. And Butcher is significant because it struck down portions of the Philadelphia income tax that granted exemptions for domestic servants and farm laborers. In other words, exemptions that carved out particular professions for differential treatment were struck down. And that's what this statute does, or this ordinance does. It targets particular professions. And really what it does is it tries to use professions as a proxy for income. And it tries to impose in practice the type of graduated income tax that this court has never allowed. The type of graduated income tax that this court has never allowed.
Say that. You can say that. However, you have to also acknowledge that professional athletes and entertainers coming in to use our stadiums place a burden on our city's resources, additional security, additional police, additional city services to take care of those athletes and those entertainers and what impact they have on the city. I mean, you can't ignore that, can you?
So we don't ignore that, and we acknowledge that the burdens that any profession imposes on the city are going to vary widely, and that professional athletes who perform at public stadiums certainly require an extent of city services that perhaps lawyers like me do not require. But there are many other, services. For example, if Taylor Swift comes and plays not at one of these stadiums, but in a public park, that's going to impose just as much, if not more, strain on city resources. And yet she's not going to pay the facility fee for that appearance. She will if she performs it in particular stadiums. And I think more importantly, imposing differential tax rates based on the perceived burden that different professions impose on the city is really inconsistent with the purposes behind enactment of the uniformity clause. And this court has detailed the history of the uniformity clause at length in Nextel and Mount Airy. The uniformity clause was enacted based on the perception that particular industries were getting unfair, perhaps rational, but unfair subsidies.
Did somebody say Taylor Swift? How many Swifties do we have out there? Taylor Swift. This is what I just said. I was like, these hoes are going to find a way around that. Why would I perform there and have to pay that? Or I just won't come to your town. Like, I'm not fucking paying that. Go fuck yourself. Like, these people are dumb.
For example, if the city of Pittsburgh was to say, you know what, the future is AI, and we're going to exempt anybody's income that's earned for working at a data center, I think that would run afoul of not only this court's cases, but the history of the uniformity clause. What the city is arguing is really just a variation of that. It's trying to say, notwithstanding that you couldn't do that, you can try to consider and ascertain different burdens that different professions are placing on the city and tax them differently because of that. And I'd submit that that's the same as trying to weigh the various benefits that different professions or different industries are conferring and doling out preferential or non-preferential tax treatment based on that.
Okay, we understand the argument. Is there anything you'd like to say in summation?
Can I ask you a question before you sum up? And I really should have asked opposing counsel this question. Where in the record, if anywhere, can we determine the manner
any.
in which credits will be given or are being given to your clients?
Sure. So I'll point to, first of all, the state law on credits, which governs where that they can be claimed.
I understand the law. I'm asking for where in the record can we determine what the city is doing?
I'm not sure that there's going to be anything in the record regarding what the city is doing beyond what it's arguing in its briefs. I can point you to the existing regulation.
We know that.
We know that.
Okay.
Yeah.
I think the only
I'm looking for facts.
I don't think there are facts in the record about credits being denied per se, because again, no one has claimed a credit they don't think law entitles them to.
All right.
Okay.
Thank you very much.
you.
Although, counsel, and very well argued, although we do not permit rebuttal in this courtroom, I am not precluded, a justice is not precluded from asking a question in the nature of rebuttal. Mr. Ashwai, can you enlighten us as to whether the city of Pittsburgh has amended its forms, created new forms to account for this acknowledgement by the city that this is indeed a tax, not a fee? And if not, why not?
To the best of my knowledge, Your Honors, because to Justice Donahue's point, there isn't anything in the record related to the handling of credits.
How do we decide this then? I mean, when you rely so heavily on minute, which involves credits for earned income tax paid, to another source.
Sure.
And there are really two questions, the credits
Right.
and that Justice Donahue's concerned about, and also just the characterization in your processing procedures and in your forms
Sure.
as to whether it's a tax or a fee.
I think there are a number of questions. So I will start with Chief Justice Todd. To the best of my knowledge, the regulations have not been amended, and there have not been creation or at least finalization of new forms. The reason for that is because this court could do any number of things. And so the city was waiting for some finality on what this law may or may not look like at the end of the day and what parameters may or may not be imposed on the
That's
law.
a good answer.
Thank you. I thought so too. Oh,
Okay, could you answer Justice Donahue's question?
yes,
Right.
and your,
God,
and
love
your
laughing.
question was, how can we decide this case if the
If we
credit?
don't know what you're doing in order to effectuate a credit for
Well,
earned income tax paid somewhere else?
the answer to that question directly, Your Honor, is we will comply with what the laws say in each of the respective jurisdictions, because different jurisdictions have different credits. And so, and to take it one step further,
Given a credit here. I thought I asked this question.
You did.
indirect.
and that is exactly what I said. To the extent that it requires to give credit where you work, credit will be given here. But I want to be very clear. The way professional athletes and entertainers are paid, unlike us who receive salaries, they receive compensation entertainers based on where their concerts are. So when Taylor Swift performs here and makes $20 million, she's not paying taxes to Nashville, Tennessee, because that income isn't generated there. That's why there can never be perfect uniformity, and that's why you need to look at the territory.
I have to follow up on this line of questioning, which in this rebuttal situation, you can't tell us. I mean, are you telling us that there is a way for us to uphold this under the promise or guise or possibility that the city is going to amend its regulations, its forms, and allow a credit that heretofore they have never seemed willing to provide?
Certainly, Your Honor, where the city is going to comply with the law, which requires credit to be given.
But the statute and the regulations and the forms don't allow this. And that's what's in front of us. It's not the scheme that you could craft that could pass constitutional muster. It's what's in front of us now. And right now, your regulations don't allow any declaration as a treatment as a tax. That's the scheme that's in front of us, not some hypothetical other scheme that you might be able to craft. The solution would be for us, if we say it's unconstitutional, is to strike this one down and let the city try to craft a new one that might comply with our decision.
Sure, Your Honor, I would respond to that by saying, again, I believe the credits are a little bit of a red herring, because in the city of Pittsburgh, you're paying no more than 3%.
I understand, but my simple point is, you can't promise us the city is going to do anything. We have to deal with what's in front of us now, what's hypothetically in front of us.
Correct. And what's in front of you now is the city has acknowledged this is a tax and will be treated as such. And
you've acknowledged in this litigation.
That's correct.
But your regulation, which your city is bound to follow until it's repealed or declared unlawful, says otherwise.
And I would conclude with, Your Honor, even under the current regulation, which does not allow a credit, because within the city of Pittsburgh's territorial limits, which is in the plain language of the uniformity clause, within that territorial limit, all athletes and entertainers pay not a roughly uniform tax burden on income, the exact same tax burden on income. What happens outside of the territorial limits of the city of Pittsburgh is not a concern or determinative under the uniformity clause.
Okay. This is unusual for us to do, but I'm going to request further briefing on this last issue, on the issue of what the city has done and what it has not done, and why, with respect to this being an acknowledgement that this is a tax, not a fee, and also the credit issue, how it's being handled and how it should be handled, what the impact is legally. And I'll ask our prothonotary to set an expedited briefing schedule. We want to get this right, and I think it's important that we understand your positions on this issue. So thank you very much, both of you.
Thank you, Your Honors.
Well argued by both sides.
It sure was. Thank you.
Oh gosh, here we go. We will be calling and oh, here we go. Very well argued on both sides.
Mr. Minner?
Oh,
Yeah.
Here
Call
we
the next
go.
case, Mr. Minner?
Oh gosh.
Commonwealth of Pennsylvania versus Sheldon Jeter, representing Commonwealth, Mr. C. Sheldon Dreyer, representing Mr. Jeter, Mr. Corey.
Okay, here we go.
Oh, absolutely. You have them all. Yeah. I use my sleeve.
Good morning.
Good morning.
In this case, appellee was convicted of first-degree murder. Following his conviction, he filed a motion for an evidentiary hearing regarding whether one of the members of the jury had been subjected to outside influence. As support for his motion, he attached an affidavit from one of his trial attorneys, Alexis Cobb, wherein Ms. Cobb stated that she spoke with Ralph Smith. Smith told her that following the trial, Smith had a conversation with Chris Gabor, the father of one of the jurors, and that Mr. Gabor indicated that his daughter, the juror, was allegedly having difficulty with the case, and that he and his daughter preyed on her decision before the jury rendered its verdict. The trial court denied appellee's motion, finding that Ms. Cobb's affidavit, which consisted of several layers of hearsay, was not competent evidence to warrant an evidentiary hearing. The Superior Court reversed the trial court's decision and held the trial court abused its discretion in this regard. In the appeal by the Commonwealth, we consider whether the Superior Court erred in concluding that the trial court abused its discretion and in reversing the trial court's order. Please proceed.
Madam Chief Justice and Justices of the Court, may it please the Court, my name is Sean Dreyer. I'm an Assistant District Attorney in Beaver County. I'm here with my boss, Nate Bible, our District Attorney, to explain to this Court why the Superior Court should be reversed and the grant of the hearing be reversed, and the trial court's denial of an evidentiary hearing in this case should be affirmed. Your Honors, I believe that the issue in this case can really be viewed under two different lenses, one a substantive one and the other one a procedural one. I think the substantive question is, what showing does a defendant who's been convicted and that conviction is supported by the evidence, what type of showing does such a defendant have to make in order to trigger an evidentiary hearing that would require the jurors from that case, or at least one of the jurors from that case, to appear, be examined and cross-examined in a formal proceeding? The other question, the procedural lens that should be applied, is whether or not the trial court answered that question in a way that was manifestly unreasonable or otherwise constituted an abuse of discretion, or to the contrary, was that decision fully supported by the record. With respect to the substantive issue, that is to say, what does a defendant have to provide or show in order to trigger a hearing? I believe that the answer was provided, and among other cases, the cases that the Chief Justice wrote when she was a judge on the Superior Court, Commonwealth versus Messersmith, which says it is only in clear cases of improper conduct by jurors, evidenced by competent testimony, that a verdict which is fully supported by the evidence should be set aside and a new trial granted. I'd note that standard comes from a case that really in 1934, Friedman versus Rolfe Brothers, articulated the same standard. So it's been nearly for a century that it's been clear that that's what, in this type of circumstance, a defendant needs to do.
How do you reconcile, I guess you can find language, well, how do you reconcile that with the fact that trial judges all the time make discretionary assessments, decisions to afford an evidentiary hearing when counsel bring to the judge's attention certain allegations or averments? There's discretion in Pennsylvania for common pleas judges to order an evidentiary hearing. It happens every day across all areas of law. And then it's at that hearing, if the judge decides to give that hearing, that the test comes in as to whether there's competent evidence. In other words, this barrier you're trying to declare or validate here is that the admissibility has to be determined prior to even getting an evidentiary hearing, and that seems at war with the way law is practiced in Pennsylvania. I mean, I think it would be a surprise to judges across the Commonwealth.
Well, my answer to that, Justice Wecht, is that in this particular instance, in the particular posture of this case, there's already been a verdict. There was a 3-day voir dire, a 7-day trial, and I think probably 1 day of deliberation stretched over 2 days, where the case had been thoroughly explored, the case had been tried, the defendant was afforded the full panoply of rights that all defendants are afforded under our Constitution, and a verdict was issued. A verdict was issued by a jury beyond a reasonable doubt. And that verdict has some degree of sanctity, if you will. I believe
I
that.
just interrupt. I mean, I think we all understand and respect the sanctity of a jury verdict. That's a given. I thought the question was whether there is some, some gold standard that says, because if we say it, it's going to be a new standard that judges in Pennsylvania cannot order an evidentiary hearing if in their discretion they think one side or both sides have made a showing that they should be able to develop evidence they say is out there. I mean, because motions courts in Pennsylvania, civil, criminal, family, they order hearings every day when they decide a party should have an opportunity to lay down a record.
Well, I would respectfully submit, Justice Wack, that this is not a new standard, that it may be a clarification of what the standard is and has been at least since 1934. But in a situation where one party is attempting to overturn or bring into question a verdict of a jury, they have to have something. If they don't have to have something, competent evidence that shows some possibility of prejudice, I believe that is the standard.
Counsel, you keep saying you keep referring to competent evidence. I mean, the only incompetent evidence in this situation would be evidence that was proffered to show what happened in the jury room. Otherwise, if the affidavit alleges facts that would support a conclusion that there was outside influence, that would be competent evidence. I mean, competence is defined by what's permissible. What's not permissible is somebody alleging that juror 1 said this to juror 2 in the jury room. That would be incompetent. Here, this is outside influence.
That would be one example of incompetence, Your Honor. I believe under Rule 602 of the Rules of Evidence, it requires one standard of competency, or one requirement of competency is firsthand knowledge. And in this affidavit,
where do you get that? I mean, what affidavit isn't going to have hearsay? I mean, there was hearsay in all of the cases that we've dealt with before this situation. Hearsay is a rule that comes into play at a proceeding. So if a judge decides to have a hearing on this and somebody takes the stand and says, he told me that she said, that's hearsay. They aren't going anywhere with that. At a hearing, somebody with direct knowledge would have to appear on the stand and testify. But an affidavit is always going to contain hearsay. It's hearsay. The affidavit is hearsay.
If I could just respond to the 2 points. I'm not sure that, I mean, if the lawyer in this case had actually spoken with the father, as opposed to merely with the soon-to-be ex-father-in-law, who supposedly reported comments from the father. If she had gone to the father, which she could have done, that Carter case doesn't.
About levels of hearsay. You're saying there's too much hearsay in this affidavit to allow the court to make a discretionary decision that he or she wants to hear evidence.
Well, I'm saying that there's 3 levels of hearsay in this particular affidavit. And I would contrast it. Your Honor said that all the cases had hearsay. I don't believe, Your Honor, with respect that the Pratt case, that the letter from the juror in Pratt was infected by hearsay. In that case, the juror reported what she observed in the deliberation room, specifically the fact that other jurors had introduced evidence from other medical professionals that they had consulted, and she said this appears to have affected the verdict. So I don't know that that is hearsay, at least in the same sense in which somebody supposedly told their father, who supposedly told the soon-to-be ex-father-in-law, who told me whatever was supposed to be said.
Isn't that, aren't you conflating the standard for getting an evidentiary hearing with the standard for getting a new trial? I mean, it seems like you're front loading this to the extent that you would foreclose the evidentiary hearing in service of denying the new trial. We're not there yet.
So I think you're right, Your Honor. So the question is, what does the defendant or the disappointed litigant have to show in order to get there? Or is this type of hearing, this type of evidentiary hearing supposed to be granted in every case or in many, many more cases, which is what I believe you will see come about if you make it easier.
Happen in many cases. I'm sorry to interrupt. I mean, this is a very peculiar situation, isn't it?
Well, this is peculiar, but the notion that defendants who have lost a trial and are facing life in prison are going to grasp at any possibility to get out of that situation, that is not unusual at all, Your Honor, in my view, respectfully. So I think that, and this goes, Mr. Jeter in his brief argues that this case really isn't worthy of your attention because it's an attempt to have error review instead of affecting public policy. I think this goes to the heart of the question of whether or not this court is going to establish a system in which jurors, as a routine matter, can expect not only to have to go to jury duty and go through all the burdens that they willingly undertake. It's an impressive thing what these folks do. They're not only going to have to do that, they're going to expect afterwards, people are going to call them back into court, maybe a couple of weeks, maybe a couple of years later, and question what happened either in the jury deliberation room or outside the jury deliberation room.
Isn't that argument belied by the focus of 606? I mean, 606 really limits the ability of litigants to bring jurors into our courtrooms for evidentiary hearing on what went on in the jury room. It really focuses on two limited prongs, one being when there's information that leads to an outside influence.
Well, there's two standards. There's prejudicial information not of record and beyond common knowledge and experience, or an outside influence brought to bear on any juror. So again, my position, the Commonwealth's position in this case is that a person seeking that type of hearing has to show by some sort of prima facie competent evidence that is a real possibility.
Well, I kind of align a little bit here with the other end of the bench because I hear your arguments about the affidavit is based on the fact that it's hearsay, and truly it's layered hearsay. And could the affiant gotten a better source of information for her affidavit? Surely could, but it seems to me, isn't the way that you test it is by giving them an evidentiary hearing? Otherwise, you're going to always deal with some layer of hearsay.
Pardon me, Justice Mundy. Well, again, I think if Justice Mundy, you're proposing a rule that essentially they don't have to make any sort of showing in order to get a hearing, then these hearings are going to be routine procedures attached to the end of every trial, or many trials. Every may be a bit of a hyperbole, but many trials are now going to feature this post-trial hearing about what may or may not have occurred in the jury deliberation room.
Commonwealth. So why don't you share with us, if we were to decide in your favor, what is it that we should write? Like, what is the threshold showing of prejudice?
Competent evidence of potential prejudice. That is to say, something more than this layered hearsay affidavit. And frankly, in this case, I'd like to point out that, again, the trial judge in this case not only denied the motion because of the hearsay, he also denied the motion because there's no clear statement in this affidavit that the father provided any outside influence or outside information to the juror. It's just not clearly stated. And
that doesn't matter. I mean, what it says is that the juror discussed the case with her father. I mean,
Did they discuss it or did they pray over it?
they discussed it.
Both. I mean, the
Yeah,
problem
both.
isn't that she prayed.
It's
The
that-
problem is that she discussed it with a third party, right?
if it's true that
That's what the hearing's for.
if it's true, that would be a problem, but it's not necessarily the type of misconduct that would warrant a new trial.
You could be right, but I mean, no one more than a trial judge would avoid disturbing this verdict more than anyone in this room. More than anyone in this room. So a trial judge using his or her discretion in this situation is going to test the adequacy of the allegations to determine whether or not this could establish undue influence. That's all the trial judge had to do here. Now, you're right, at a hearing, maybe there won't be firsthand testimony of any of this. I mean, obviously, the father would have to testify, or the juror would have to testify as to the discussions. But that's not where we are here. All we have here is a trial judge who said, well, if that happened, there's a problem here, or could be a problem here. I don't know. I mean, a trial judge, more than anyone, would want to avoid upturning a jury verdict. That's why the exercise of a trial judge's discretion in this circumstance gives me a lot of confidence.
He turned down the request for a hearing, right?
I'm sorry, Your Honor?
Overturned, yeah.
Yeah. The trial judge turned down the request for a hearing. He was overturned by the Superior Court, right?
Yes, Your Honor.
The judge married the
Well,
juror.
the only thing I would say, Justice Donahue, in response to your comment and sort of dovetailing with the comment Justice Wecht had made earlier, is that would indeed be a new rule. That, as far as I can see, and as far as the cases that I've read indicate, there's never been a situation in this Commonwealth where the rule is you're automatically entitled to the hearing. The rule.
That's not really the basis for the reversal. I mean, the Superior Court's basis was not on the premise that, of course, we all know the reversal was not premised on the notion that litigants are automatically entitled to a hearing, because we, as much as you, would rue the day that every person convicted, automatically gets this sort of hearing. So there's no disagreement there. But the reversal here was premised on the analysis that the trial court undertook in denying.
Well,
That's what we're debating about here. That's what we're hearing you argue about, whether this sort of gold hearsay standard is the rule.
Well, and also the focus on the abuse of discretion or lack of abuse of discretion of the trial judge, right?
Well, the Commonwealth's position in this case, Your Honor, is that in point of fact, although the Superior Court said that the lower court judge, the trial court judge, abuses discretion in denying the hearing, they did not, in fact, apply that standard. They did not discuss what the judge actually held.
They just disagree. Your argument is they just disagreed with whether or not the hearing should have been granted, rather than demonstrating how the trial judge abused his discretion.
Right, and the standard for abuse of discretion, as the court is well aware, is exceedingly high. It's manifestly unreasonable. It's not applying the law or applying the wrong law or showing evidence of partiality, bias, or prejudice. And the standard is that if there is support in the record for what the lower court judge did, then the appellate court, including, although I say it with some trepidation, this court, should not overturn that decision in the absence of an abuse of discretion.
Which is an error of law. An error of law is an abuse of discretion. And I think that's sort of implicitly what the Superior Court was talking about. That there was an error of law.
But they didn't point out what the error of law was. They said there was an abuse of discretion without going through I'm sure it's a somewhat laborious task to explain what exactly the trial court held and why it was manifestly unreasonable. They didn't do that.
I'm sorry, I thought, counsel, it was that under Rule 606B2, juror number three would clearly be competent to testify to that, and that in a case of this gravity, the court ought to assess whether this in fact occurred. This little like prayer together session with an outside person.
Well, it depends, Your Honor, with respect on what prayer means in this context. That might mean different things to different people.
I think it matters.
No,
I think
prayer
the
with
fact,
another person.
I think the fact that there's another
That's
person
the point.
is the problem.
Well, that may be misconduct, but it's not necessarily the sort of misconduct that would entitle the defendant to a new trial, unless there was some demonstration that the father or some other party provided information or some external influence on the
Harder
juror.
that prejudiced the juror, right? The prejudice.
That I think, in addition to showing that there was external influence, it had to be prejudicial, and I think those are two separate requirements.
Well, the affiant said that Mr. Gabor, and this is quoting from the affidavit, the affiant states, Mr. Gabor and Mary talked about the case. They talked about the case during the jury deliberations, and that she was having a hard time with deciding what to do, and that she and Mr. Gabor prayed on it, and after they prayed, she made her decision. It seems like the juror, at least, would be competent to testify at a hearing under 606B2.
Oh, there's no doubt that if the defendant's entitled to the hearing, which is the issue here, if he's entitled to that hearing, then obviously the juror, obviously in my view, that juror would be competent to testify to any communications she had with anybody apart from communications in the deliberation.
Not her thought processes during deliberation, but this outside.
Right. But the question is, do these very tissue thin allegations in this affidavit rise to the level that would justify a court in calling that juror back into court now to render an account of what happened 4 years ago? Now,
Just a second. Why are they tissue thin? If true, they're not tissue thin, and we don't know if they're true unless we have an evidentiary hearing.
well, I don't think we know what they mean with respect, Your Honor.
I mean, she spoke with someone else, her father or any third party. They prayed on it. She can pray on it herself, certainly, but she involved a third party and discussed the case. They prayed on it together, and she then was able to make her decision. That's troubling.
I understand why it's troubling, but I would submit that, again, there is a conflation here between what is arguable misconduct, and again, it comes in various levels and various degrees, versus an outside influence. If the information or influence was all from the juror to the father,
That's misconduct, but not prejudicial. Is that what
well,
you're
it's not external influence. It's her maybe unburdening herself to her father about the problem she's encountering in the jury room.
Yeah, I mean, that you just said that maybe the court ought to, I mean, if it's garbage, the court, an experienced, any judge is going to recognize it's just garbage. But how you can just say there's no evidentiary hearing on an allegation like this in a murder case, I mean, you've got strong evidence. If you have to try the case again, you try the case again. But I mean, I don't know. I'd be surprised if many judges would deny an evidentiary hearing on a murder conviction with this kind of affidavit. And it looks to me like a pretty darn serious allegation.
But I'm somewhat paused, and Commonwealth, share with me. The issue here is, did Superior Court substitute, I guess, its own judgment for that of the trial judge? And we're giving the trial judge great discretion in making the determination. And in that judge's determination, he felt that the affidavit that she spoke to her dad and they prayed on it there's no other evidence submitted before that trial judge to prove that there was any outward undue influence. They prayed on it. At best, they're religious.
Yes, Your Honor.
So I'm confused. What's your position with regard to the trial judge's decision? Seems like this court's kind to support the Superior Court's position when the real focus is on the abuse of discretion of the trial judge. And since that trial judge has great discretion, where did he abuse it? Do you believe he did or he did not? How do you argue this?
Well, Your Honor, our argument is that there is, frankly, if you review what the trial court said in its 1925 opinion, he very carefully identifies what the applicable legal principles are. He applies those legal principles to this case, both in terms of competency and prejudice. and concludes that both are lacking.
And that's your position.
And that's what the law requires.
The Superior Court substituted its position.
Right. And
Okay, that's good.
It's a good argument. Problem is, they
Thank
have
you.
a good argument too.
We'll see.
it's very distinguished counsel.
All right. Is that it?
If that's all the court wants to hear,
Oh, thank you. Very well argued.
thank you very much. It's been
Thank
an
you
honor to
very
be here.
much to the Commonwealth. Mr. Woods, you must like it here. You keep coming back.
I'm going to start sleeping in the coat room. Thank you, Chief Justice Todd Corey Woods here today for Mr. Jeter. I think the court has kind of hit on the issue here. There's a lot of questions about what actually happened, and that's why I wanted an evidentiary hearing. I wanted to be able
Tell
to.
the judge abused his discretion based upon the evidence you submitted and the arguments made.
Sure.
That's
So,
what we're here for, not what we believe to be what we would do if we were trial judges, but tell us what that trial judge did that was abusive.
And not what the Superior Court would do. or
Right.
would
that's-
have done, but
right.
what the trial judge did, and did he abuse his discretion?
so the trial court determined that because this was hearsay and it didn't
I want to raise the microphone.
Sorry. Because this was hearsay and because it did not fulsomely establish exactly what was said in prejudice, that we're not going to give a hearing. Maybe in 1999, that is a reasonable statement of the law. The problem is that we've already been through this. In Pratt, there was a letter, which is a hearsay statement.
But that was a detail. That's easily distinguishable. The content of the Pratt letter was very fact specific. This was just that she had a conversation with her dad because she was troubled by her decision, which is a weighty one, someone's life, and they preyed on it.
But that's
I'm still confused as where this bias prejudice is coming from.
So let me just walk through what exactly was in Pratt. So we have a hearsay letter purportedly from a juror. We have a statement in there that other jurors said to her. That's another hearsay statement.
Do we take into consideration that the hearsay from the father is that he didn't trust the legal system, so he didn't want to supply one?
Well, that's not exactly right, Justice. I'll flip this around. In this case, we have a sworn statement, which we didn't have in Pratt, from an attorney, which I think has a little more credibility
The
than.
losing side's attorney, right?
That's correct.
Okay, should we take that?
But we
into
have
But
consideration?
an officer of the court.
an officer of the court with ethical obligations
I'm
and
not
some skin in the
saying-
game.
I'm saying that it's
Um,
disingenuous. Should we take in the fact that the losing attorney decided to submit something about somebody who doesn't trust the system?
I suspect that Attorney Cobb would much rather have had Mr. Smith sign out an affidavit if he had been willing to do so. We have in this case, we have a sworn affidavit from counsel that father-in-law was told by father that father had this conversation with the juror. It's 3 layers of hearsay. I get it. We have the averments, and I want to be very specific. The Cobb affidavit at paragraph 11 says we talked about how she was a juror and what was happening during the trial. We talked about paragraph 12. We talked about the case during the jury deliberations and that she was having a hard time with deciding what to do and that she and father prayed on it. And after they prayed, she made her decision. So it is true that that is not a fulsome explanation of what this conversation entailed.
But isn't that what's before the court? The judge has to decide, based upon what you submitted, whether that's sufficient for the standard of prejudice.
In another context, I might agree with you, Your Honor. But when you look at the Pratt case, here is the language. So first of all, the Superior Court and Judge Del Sol and Judge Klein, they say, okay, we get it. We get it's not clear. And we're going to have a hearing about it. And Judge Kavanaugh dissents and says, well, yeah, it's hearsay and it's not fulsome enough. Well, he lost. And then before this court, back in 2001, Justice Saylor puts kind of a fine point on it. He says, we acknowledge appellant's arguments. This is from the Pratt case. We acknowledge appellant's argument that Juror 10's affidavit lacks specificity in material respects, and if believed, would not establish the quantum of prejudice necessary to disturb the verdict. So it's the same thing. It's hearsay. It doesn't. All that it said was we talked to somebody about the standard of care.
And that was a
No,
civil
that's not
case.
true.
This is a murder case.
I apologize. With all due respect, the Pratt letter, it indicates that despite a medical malpractice and the testimony of a CAT scan, that they went and spoke to their own professionals. They sought out conflicting doctor testimony. At no time did they say to their dad, I'm struggling with a life case. And he says, let's pray on it.
But we don't know whether it's conflicting. And that's stated in the Pratt case.
Burden of the-
We don't know whose ox is even gored. It may have been helpful to the party who won.
that was the
It's a
purpose.
cipher.
But isn't that the burden of the attorney who's bringing this allegation to provide the court with the sufficient competent evidence needed for him to determine whether it's biased, not afterwards?
No, and here's why. Ordinarily, if we're doing a motion to suppress, if we're doing whatever a motion to eliminate, yes, 100%. But in Pratt, Justice Saylor goes on at some length for Justice Saylor. That means 3 paragraphs instead of 1. He says, this is a different context. And this is what I want to get to next. Here's why. We don't want attorneys or their investigators going out to a juror or going out to the juror's dad and saying, hey, we need to put competent evidence in front of the court to show, hey, we need a hearing here. Because the court has said there's a case with an exclamation point in it that says, don't do this anymore. And so we don't want them to do it. And number 2, one of the reasons we don't want them to do it is because we want to give the trial judge control over the situation. We want to give the trial judge the ability to police the boundary between competent testimony and incompetent testimony. Because if you send that investigator out there, he's going to go to the juror and they're going to talk all about how the case got decided inside the jury room.
Your position is the trial judge was either incompetent or abused his discretion based upon the facts and the evidence before him at that trial, at that motion?
So it can go either way.
I'm trying to find which way to go.
It can be either one, as Justice Donahue alluded to. This is an error of law because under Pratt, this is sufficient reason as a matter of law to.
If it meets the Pratt standard of the specificity and the factual basis that the Pratt letter, but you can easily distinguish what's written in Pratt and what's written in this affidavit.
Well, I think they're factually different, but I think they're factually identical in material respects because, again, in Pratt, we just know that they talked about the standard of care and specifics about the standard of care. But in Pratt, we don't even know who it helped. So
Let me quote from it. Beginning during the trial and continuing throughout deliberation, some of the jurors reported that they had spoken to various people, such as relatives and friends, involved in the medical profession and their personal physicians to get their opinion regarding whether a CAT scan could have been performed earlier, whether a meningitis test and a CAT scan should have been performed at the same time, and whether this was standard care for 1989. Now, you're going to say an individual who has trouble making a decision with a life or death case speaks to dad and says, I'm troubled. And he says, let's pray, is analogous to this. I'm just trying to understand the weighty issue here.
So it's not just that he says, let's pray. It's all those other allegations about, we're talking about this. So what does that conversation entail? And how does counsel have the opportunity to develop that? We don't. We're not supposed to do that.
You could have brought the father in.
We're not supposed to do that, and we can't do it until we've got an evidentiary hearing, which was what I was arguing when I was asking for the evidentiary hearing. I said, Judge, look, I can't send an investigator out there.
Can you file a petition for extraordinary relief?
This court has said I cannot do it. I can't subpoena the guy who won't sign an affidavit.
Oh, I got that.
I can't get the guy into court without a subpoena.
You could have asked him. He may have come. He didn't trust the court system to sign an affidavit.
Sure.
But that doesn't mean he can't be invited to testify.
If we had gotten a hearing, I would have subpoenaed him. I would have subpoenaed father. I would have subpoenaed juror.
Except the trial judge felt that the affidavit was not tantamount to sufficient competent evidence such that Pratt mandates.
And let me just push back. I
The question is,
understand.
How is that an abuse of discretion for this court to get down to say that judge made the wrong decision based upon that moment when he compared the Pratt affidavit with this affidavit?
And just so you understand, that's a very hard question for us. How can you demonstrate
Correct.
that that was an abuse of discretion?
That's the issue.
So
Not our
I understand that the Pratt affidavit is more factually developed, right? It says more facts about what the conversation was. But here's the basis of decision from Chief Justice Saylor. And he's talking about how the affidavit lacks specificity in material respects. He says, for example, Juror 10's letter is not specific in terms of whether the extra record information allegedly communicated to jurors was favorable or unfavorable to appellee's position as plaintiffs, or whether it was received by majority or minority jurors. Although the tenor certainly raises the implication that the unfavorable information was received by majority jurors. So, when there is sufficient reason, it's almost like voir dire, right? When you have it's the couple of voir dire cases that the court had a couple of terms ago is probably considering now. When there's sufficient reason to raise a judicial question, what's in here, and what is the content of these conversations? Until you have that hearing, there's no way to evaluate prejudice. You just can't do it. And if this case, the principles that the trial judge used were it's hearsay, triple hearsay, true in Pratt. It's not competent evidence, true in Pratt. And it doesn't identify objective, it doesn't identify exactly what the conversations were, true in Pratt. Look, Judge Del Sol thought about it. They came down, those three things don't matter. Justice Saylor and this court thought about it, said, well, that doesn't matter because we don't want them developing it further. We want the court developing that. And look, here's another thing I want to just mention.
Can I jump in there?
Sure.
But that's not the limit. That's not the limit of the trial court's analysis in this case, that it was hearsay on hearsay. The trial court looked at the affidavit and said, and I'm quoting from his opinion, there is no allegation that Juror 3's father told Juror 3 anything. Therefore, there is no allegation in Attorney Cobb's affidavit that Juror 3's father provided any information to the jury that the jury did not have before them at trial. And that is markedly different than the allegation in Pratt, where there was information sufficient in that situation where the juror said there was testimony that was brought in, there was discussions from other jurors about outside medical professionals not involved in this case and what their input was on the CAT scan, et cetera, et cetera.
Sure. And if that were true, I would understand that that's a factual distinction, but it's not true.
I don't know if it's true or not, but it's your burden of proof, correct, to get the evidentiary hearing? And if it's not true, then the trial judge clearly, if it's true, what the trial judge wrote, it clearly is not an abuse of discretion. And if it's not true what he wrote, based upon the language of your affidavit, why didn't you say in the affidavit, it's my information and belief that juror number 3's father told juror number 3 something that she impacted with the jury in this case?
So first of all, I think the fair import of the affidavit is they talked about this. They talked about it. When you look at the affidavit, there's a conversation about what's going on in the case, what to do, and she's having a hard time. It's a conversation.
Let me stop you there because I'm listening to everybody's well-made points here. But as somebody who actually presided over 40 or 50 jury trials a year and then sat on a couple hundred PCRAs on the Superior Court, if I'm listening to what your argument is, you seem to be arguing that every time these kind of amorphous allegations are made, we have to have an evidentiary hearing. And while I think everybody up here would say, well, why don't we just give it a hearing and flesh this particular issue out? The issue I'm concerned about is future cases where you seem to be suggesting that everybody gets an evidentiary hearing because of something that was said to somebody's father-in-law, which may or may not have impacted the jury. I think what we're lacking here, and what Justice Mundy and Justice Doherty are really hammering at, is the lack of specificity. You just said it yourself. It implies that there was discussion, but you don't provide any detail. You don't provide any.
It says there was a discussion, right? It says she discussed it with her
But
father.
there's no detail about what they discussed. I mean, other than we prayed on it.
And I agree with that. I understand the court's concern.
I'm looking for a bright line here, and you're giving me, we should just have a hearing and figure it out.
Well, I'm gonna give you Pratt, and I'm gonna give you the reason why in a second. But I'm gonna give you Pratt, and it says exactly what you just said. There's no specificity here, because the overall question is prejudice, right? Is this objectively? I'm sorry.
Are you asking us to overrule Pratt?
No. They are, because Pratt says in that passage I keep going back to, the overall question is prejudice, right? We acknowledge that the affidavit lacks specificity in material respects, and even if believed, would not establish the quantum of prejudice necessary. So in Pratt, this court said, yeah, the affidavit's not specific enough to get us there, but you have a duty to investigate because in the following paragraph, Justice Saylor says, attorneys, even though it's your burden, don't go investigate. We don't want you to do that. So I can't go and write upon information and belief there was a conversation, the conversation went both ways, because I don't know that, and I shouldn't know that. I'm not allowed to know that. So I understand this is a slightly different pleading standard than it is for just about every other motion there is in the Commonwealth of Pennsylvania.
Let me ask you this, Mr. Woods. Under Carter, is the standard for establishing prejudice going through the analysis of Pratt that the juror took this information back to the jury, or simply that this juror was somehow prejudiced? So
That's interesting because Pratt's a civil case, right? And so there's minority and majority jurors, and we talk about it in Pratt. Here, one's enough. So it doesn't matter if it goes back to the jurors.
Right.
Counsel, let me try to put a fine point on this. And I'm starting from the proposition that jurors are instructed not to discuss what's happening in the case with anyone outside of the jurors, correct? Okay, so that's sort of the overriding principle here.
Correct.
And so we have an allegation here that this juror discussed the case with someone during deliberations who was not a juror. Is that sufficient on its face to establish the ability to have a hearing to determine whether or not there was indeed outside influence? It may be the father said nothing, although discussed would suggest otherwise, but is that enough to allege that a juror broke the rule that you are not to discuss what's happening during this trial with anyone outside of the jury?
And did that misconduct cause prejudice? Because even if she committed that misconduct, it doesn't matter if she's not prejudiced by
And
it.
when do you determine prejudice?
Yeah.
So my reading of
Answer all those questions at once.
great. We'll just walk through the post-trial phase. My reading of Pratt is this: when there is sufficient evidence to raise a judicial question, the trial court has a duty to investigate. Maybe that's a hearing. And look, Justice Saylor says the procedure for doing this is up to trial courts. So maybe the judge can just do an in-camera inspection. Maybe there's all sorts of tools that the judge can use to inquire here. But the sufficient evidence of potential misconduct that is potentially prejudicial creates a duty to investigate on the trial court's part. And once that investigation goes on, that investigation is subject to abuse of discretion. Once you've had your factual development, however you get there, that's when you apply Carter. That's when you say, oh, now that this allegation was raised and we've looked into it, is this likely to objectively likely to bias somebody? And look, I I said at the post-sentence motion hearing, maybe we have the hearing and, father comes in and says, well, we just never had that conversation. This is just some guy on the street saying it's completely false. And then I call the other guy and he says, no, he told me. The trial judge makes a credibility determination. And then wherever that goes, I go.
So, Mr. Woods, what you're saying is if we were to follow your recommendation as articulated by Justice Donahue, that anytime an individual sitting in the jury, but hypothetically a defendant family member sits in, watches the trial, verdict comes back guilty, we're now permitting someone to make an allegation, oh, I watched juror number 4 and 5 talk, or I heard them say, or I seen her at lunch, and that now gives us carte blanche to hold an evidentiary hearing over each and every allegation based upon hearsay.
No, I'm saying when there is sufficient evidence that there is external influence, legally sufficient evidence.
So are you sharing with us that from the affidavit, that particular, I have the affidavit, let me see what's your very minute.
It's paragraphs 11 and 12.
Are you saying that that is sufficient, that I had the conversation and that we prayed on it, is sufficient evidence of undue influence or prejudice?
I would go broader than that. I would say that we're let me just get the language right. We talked about how she was a juror. Maybe that's fine. What was happening during the trial? We talked about what was happening during the trial.
Is that a crime since these are open criminal or prejudicial or influential when every criminal courtroom in the Commonwealth is open to the public?
It's not a crime, but if we went downstairs and someone was talking to a juror about what was happening at the trial, I think the trial court jumps in and says, hey.
That's my question. What would
Right.
happen if this came up during trial?
Oh, exactly.
What happened if this allegation was put forth before the jury verdict was rendered,
Right.
brought to the trial judge's attention that juror A was seen in the hallway talking with her father about the case?
Right. I think.
What would happen?
You'd colloquy them.
Well, you have a colloquy.
You'd
You'd have
colloquy. Correct. You would
investigate
colloquy the
further.
witness. You'd bring the witness in. You'd ask about who they were speaking to, what the content of the speaking, whether or not they received any information that might adversely affect or impact.
Exactly.
And then you would ask them whether or not they imparted that information to the other jurors.
Right. And then you would make a credibility determination.
And remove them and replace them with
The alternative.
That's different.
The point of this,
Completely
the point
different.
of this is that the denial in such circumstances of any inquiry or hearing on that alleged contact would be error.
Right. And you can call it an error of law if you use a sufficiency construct. You can call it manifestly unreasonable because it's clear that someone has an obligation to investigate under these circumstances. But at the end of the day, there's a judicial question about whether there's a 13th juror in this case. And I just don't know any basis that we can say it's okay to not inquire about that.
Right.
argument.
And just to be clear, you're not asking for us to reverse a murder conviction. You're
No.
asking for an evidentiary hearing.
Right. And look, that's what I thought would happen. I thought we would get a hearing. And there's one more point that I want to just get out there. Part of this is you have the hearing now. You have it when it happens so that you get the evidence right away. So this was 4 years ago. Now the witnesses their memory's not so good. Who knows who's talking in the community? We have, in this case, and this is not Mr. Bible or Mr. Thank you, Mr. Dreyer.
Father-in-law is no longer the father-in-law.
Right, but we had the predecessor district attorney go out and interview dad, unbeknownst to me, while they're saying, "Hey, you can't go do this in court." So that's going. So now are we calling the former DA to talk about what dad said during, there's stuff there. We have one of the potential witnesses from the other claim somehow got the trial judge's cellular phone number and is sending him text messages that he's disclosed. So, and I'm not saying this is not about that, but this is about it's important to deal with this right away, just like you would if they were in the hall, because that's when the evidence is most reliable and it can be managed. And we cannot have conversations about, oh, well, what did juror X or Y say in the jury room? We can have conversations. Well, what did you say to your dad, and what did your dad say to you? And we're done. That's what this is about, and it's about protecting the court. It's interesting. We can. I think there's an attitude that what I'm doing here is I'm saying, hey, impeach this jury verdict. We're trying to mess things up here. But what I'm saying is we need to. The trial court had an obligation to investigate here to protect the jury verdict. The trial court's investigation here would police that boundary and manage this case. By not doing that, we're 4 years down the road. Who knows what this hearing is going to look like now?
All right. It's really an interesting case. It was well argued by both sides, and we appreciate it. Thank you both.
Thank you, Your Honor.
Thank you.
Call the next case, Mr. Minner.
All right. I think he's going to get his evidentiary hearing. Corey Woods just dropped some bombs there at the end. There's so much that people don't even know what has transpired. We have a person in the media that got the judge's personal cell phone, okay, and started emailing and texting him. The judge in this case was texting with the media. The shit that's going to come out in this case is going to blow everybody's minds. I've never stopped working on this case. Sheldon Jeter Jr. is innocent 100% in both murders. Aliquippa, Pennsylvania, as well as that area, Beaver County, extremely racist area. But more importantly, they were trying to literally clean up and sweep up this whole Del Tondo murder and blame it on Sheldon Jeter Jr. But in order to do that, because there wasn't enough with the Rachel case, and when I say enough, they tried to pin that on him. It was going to bring out way too much shit, which then would have led to the truth. And Santa Cola wanted to defend Sheldon with that. But when it came down to the fact that 2 years later, they're like, hey, we have to make this kid out to be a murderer, and then we'll pin the Rachel case on him. And that's exactly what they tried to do. So much so that after Sheldon Jeter Jr. was found guilty, this trial lasted 7 days. Voir dire was 3, trial was 7. And the jury got the case in like the afternoon and then came back. So like overnight, this whole conversations and stuff were happening. Then the jury comes back the next morning and has, this decision. 7 days. Murder, first degree murder case. Get the fuck out of here, man. You want to barf. There was a 13th juror. Her answers with her voir dire are very interesting. And that's all I'll say. I think that you guys heard. So what they do is they vote on this. And so how I see this looking is, if you can hear the different voices in the back, I feel like it's going to be 2 people that are going to go against it, but the majority is going to go for it. And that's where you're going to get your decision, and that it will be upheld. And it will go back to the trial court, which means there will be an evidentiary hearing, which means all of these witnesses that we're talking about that you heard there at the end, there's bombs. That's the district attorney. The stuff that's going to come out in that. And then the dad, the father-in-law, and then the juror. And I think there might be a surprise witness. Because a lot has transpired. It's been a long time. This is still Sheldon Jeter Jr.'s direct appeal. We haven't even gotten to the to like any ways that he can do his post conviction. Like he has ineffective counsel all day. There's Brady violations in this case, ridiculous Brady violations in this case. Like we haven't even sniffed that. So Sheldon Jeter Jr.'s jury there was nobody that was African American on his jury. None. Think about that. How do you not have one black person on that on that jury? It's pretty wild. Black man facing murder, first degree, which is automatic life without the possibility of parole in PA. And if the jury would have been able to see 1/10 of what I've uncovered, it's sick. The defense put forward not a single witness. I think maybe one. All right, guys, we'll see you on the flip side. As soon as this decision comes out, I will let you guys know. Prayers for Sheldon and prayers for Pugh's family, both of these families. It tore apart that community, and I have nothing but love for Aliquippa and all the people that I've met over the years there. Special shout out to Sheldon's family, the church. You guys never gave up, and you guys are still fighting. Continue to do that. All right. Good afternoon.